Hey viewers, very interesting. We are going to talk about legal research and writing, but particularly I would like to begin by legal writing skills because we cannot even imagine carrying out a research without knowing how to write or knowing how to read or how to do the analysis. Well, this is very interesting indeed. GPR 117 as a code at the University of Nairobi Faculty of Law is taught to first years, first semester law students as one of the core units that are taught for those who are to graduate in bachelor in laws. But it is very important that we get to understand the general picture of what it is, and that is the general overview, in which I'm going to talk about the objectives, the goals, the purpose, but also the structure of this series. Now, the first part that is going to deal with the legal writing, and the second part that shall be dealing with the legal research will have series of videos that are going to be codified in a manner that they become traceable for our audience and for you in particular in this case. It is very good and I find it easy to put these things in video so that you can play the video back. You can review what you have listened to, and also you can repeat it to yourselves. This is how we learn because even learning is a process. Now, when we say legal writing, of course, we do know what it means to write. Writing is a skill, it is an art, whereas reading also is a skill, it is an art. But when we say legal writing, already it is the art of writing, but in the area of law. Anything pertaining to law and is put in writing is what we refer to as legal writing. This one may, as it appears, sound very difficult, ambiguous, technical, and very difficult, first and foremost, to comprehend, especially by those who do not have any good background in law or legal practice or judicial practice. But that one shouldn't worry anyone at this particular time. And that is the reason why it is better taught to first year students in first semester so that the students start interacting with the reality of law in terms of legal culture, the language first and foremost. When we say the language, we are not just talking about English, Kiswahili, or Kizulu, or Kihindi. We are talking about a professional language with its own technicality. For instance, I want to give you just an example. Those who study medicine and they become physicians and they operate in health services all over the world have got a language of their own. They have certain vocabulary that those who do not belong to that profession may not understand, but also their way of writing. Yet for them, they understand it very fast, very quickly, and easily. They get the content very fast. This is what we refer to as the professional language. Law as well has got a similar reality. This is the legal language that is used by the practitioners, by the scholars, academics, by lawyers, attorneys, and those who provide legal service within that faculty. Again, we need to understand it is within a jurisdiction. Our jurisdiction is English common law legal system, which is operational within the Commonwealth worldwide, in the United States of America, in the UK, in Canada, in Australia, New Zealand, in India, and many other countries, in Nigeria, in South Africa, I've said, and also in Kenya, in Tanzania, and in Uganda, and all the rest of the world. This simply means that the type of legal language used within the framework of Commonwealth should be understandable across the board. We can only write within a language. We can only read within a language. Now, when we say legal writing, we are talking about it in English, but also in the legal language. When we talk about legal reading, it is also within a language. Let us go step by step. Step by step, we begin by the objective. The objective number one and the fundamental one is to enable first-year law students to interact immediately and also constantly with the type of expressions, the type of language, the type of vocabulary, idioms, as well as the way lawyers talk and argue. It is to prepare them to talk as lawyers, think as lawyers, and also argue as lawyers. In this case, they cannot do it if they do not attend this course and pass it at the examination. Students will be again, as objective, encouraged to carry out series of practical work, exercises, writing, and it is very important because it is as simple as that, in the sense that you could be asked to change a plain language into a legal language. You could be asked, for instance, to change maybe a story of a mother who has had serious violations in her relationships and is seeking justice. She's not a lawyer, but she's speaking to you in her language, which is the plain language or ordinary language. But it is now your duty to use the bolts and nuts of law, and that is in the language, to use your writing skills, your capacity to comprehend and translate what you hear in plain language, plain English, into legal language or legal English, because it is a profession. You change it into a language that you want other lawyers to understand. So when you're writing to a recipient, you are writing to an audience, you are writing to a fellow lawyer, you are writing to a judge of whom you expect an amount of understanding and getting the content very quickly and very easily. I say quickly, I repeat, because somebody's asking why quickly? Why quickly? Because of the time essence, the time factor in writing, in legal writing, the time factor in the practice of law, in the sense that the court shall dedicate an amount of time for the petitioner or the claimant and an amount of time for the defense, for the parties, so that both parties can utilize their time profitably, constructively, but also effectively to persuade the bench. The defense will as well do the same, having all the prepared documents in writing, and do the same within an allocated time. When we say easily, get the content easily, is that the reader, in this case, the person reading the work that you have written, must get the content easily. easily means our writing skills must actually ensure that the content is conveyed to the recipient with clarity that is it deserves. It is in that manner, whatever you are going to do in terms of writing must as well be very communicative. That means it must have communication effect, but also must be persuasive enough without any contradiction. Now, let us again look at here what lawyers always argue about. Lawyers argue about facts. What are facts? Facts are the happenings, they are the phenomenon, they are the events, they are things that happen to people in our society in the real time within a given space and time that we can easily understand and comprehend. These are facts. They are happenings, they are actions and inactions. They are commissions and omissions. Like now, there is a fact that I am teaching, and there is also a fact that you are listening. Both of us, we are doing one important thing. We are communicating. One is speaking, the other one is listening. And the one listening is interpreting what the other one is saying. That capacity of interpretation is critical in the legal practice. And that is why I would like to base this lecture on a particular book, the Legal Writing Handbook, an analysis, research, and writing by one not other than Professor Laurel Courier Oates from Sadler University School of Law in the United States of America. And the book in its 5th edition is widely read. The handbook is what I do as well recommend for this class. From this perspective, we can see that the language of law is very unique, and particular when it comes to the plain language. When we say, I stand for so and so, this is expert lawyer or legal consultant, a lawyer representing a client in court. In that case, he stands for, not for himself, but for the client. I speak for, or I hold brief for. So this is not just as any ordinary language. And to substantiate this, you need to get into the legal language, which we talked of prior. Now, the writing. When we talk of writing, this is still at the introduction, we are saying you must write clearly. Why? Writing is the main tool of a lawyer, of a legal practitioner. What is the lawyer writing? What are you going to write? People write books, no problem. People write journal articles, no problem. But lawyers on a daily basis do write, and most of their time they spend writing. They take notes, and they must make sure that what they write down can be read by another person who is going to interpret it, translate it, and understand the content very quickly and easily. Now, this is where the rubber meets the road, because when we say your writing must be read by the reader, you are writing not for yourself, but you are writing for somebody who, at the other end, must read and understand. In the submissions that lawyers file in court all the time, everything is in writing. And when they write in a clear way and having in mind the communication of the content, that must be quick and must be easily understood by the reader. The judge here is the reader, and the judge here will read, go through, and also either admit or fail to admit. Inadmissibility of such submissions occur usually because of the lack of writing skills. Maybe the writer was not clear on certain points or does not show the merit of the case. So this is where, as a legal practitioner, one begins to failing in the writing skills. Writing skills is that you must respect grammatical rules, that is, the grammar, the tenses, and also the arrangement and the order of words. Even if there is a particular language and technical formats that is acceptable within the legal practice, it shouldn't appear that lawyers are the poorest writers on earth, on the planet Earth. Ridiculous. Because now what lawyers write should also be read by the media practitioners, by journalists, for the sake of reporting. What you write shall again go down the records and can be used for citations, for referencing, and shall be relied on as well for interpreting the law under the case law. So it's a chain of so many issues that need at the same time to be understood and to be taken together. I'm very sorry and I apologize for the background noise. It is beyond my control. Now, I was saying that writing skills will take us through this, and we are going to look at that. But writing must also be understood to be partnering with reading, because you write for somebody to read, but you must also be able to read in order to write. You cannot write what you don't know, because reading helps you to get the knowledge, to understand. So lawyers do read so much so that reading becomes part of them. As they say used to be some years back, I'm reading the law. Not that I'm studying the law. Where did you read the law? I read the law at the University of Nairobi in Kenya. I read the law at New Delhi University in India. Reading the law has been used for quite a long time because law is meant to be read. That is it. You, at that point, you are not writing it, you are reading it. But why do you read the law? You read the law in order to understand it. So even when you are writing it, it must be orderly, organized, structured, and also codified in a manner that you easen the reading and you make the reader read quickly and easily and get the content at the same time. This is good for interpretation. It is good to save time. It is good to help us engage with this subject that we are going to talk about. Now, we can say writing and reading are like inhaling and exhaling, breathing in and breathing out. That means both of them must coexist. When you read also knowing what we call marginalia. Marginalia, if you have heard about it, is just that on the side of statutes, there used to be a margin, a column of space where some codes of referencing of that particular paragraph were put. But when you read, that space also is helping those who own those copies to jot down some notes, so that when you come to the bottom, you'll be able to know the key points in the content in this paragraph and that paragraph. And those paragraphs also are arranged in terms of numbering. We are going to talk about that at a later stage. How the statutes are arranged, how the constitutions are arranged, and how you can get what you want in the book of law or in the code of law. That is actually very critical. And also how to make citations referencing to those particular cases. These are what we call legal authorities for citations. And here again, we need to understand the OSCOLA, that is the Oxford Standard for citing legal authorities, which again we use as one of the key guiding books or handbooks for legal writing. And I do emphasize that in this case, remember that legal writing is going to help you as well in writing your research paper, term paper, or research project, or dissertation, or PhD dissertation, or LLM dissertation. Why? Because it helps you also to know how to do the citations, how to do the referencing, how to write bibliography, but also how to make reference and quote maybe another work. There are rules and there are also guidelines in the OSCOLA. So these are all the things we are going to engage in: how to write a case, how to know that if I write State versus Mr. X, that is already telling me that it is a criminal case material. If it is written Mr. X versus Mr. Y, I know immediately that that is a civil proceeding or a civil case. So writing is very important, and we are going to start at a very high pace. And the takeaway here, I repeat, was to give you the introductory part component of this series so that those who attend this course and those who are going to sit for the examination can as well make reference to this and get more engaged. I would like to say that for the next video series, we are going to go systematically, logically, and in order so that we get to understand what we need to understand within the shortest time possible and the shortest time allocated for us. Thank you, and bye for now.